Welcome to Impact Makers Radio, helping you to find jargon-free information before choosing a professional to help solve your problems and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And during this segment of the show, I have collaborative family law attorney Jeffrey Wasserman. Now, Jeffrey is the principal of Shapiro, Blasi, Wasserman and Hermann, PA in Boca Raton, Florida. Now, Jeffrey will be talking to you today about selecting your divorce process, which sounds like a very interesting topic. So, if you are one of the many people out there seeking jargon-free information so you can make an educated decision before taking on any form of professional help, you might want to stop what you're doing, down tools, find a quiet spot where you won't be disturbed, and listen in to what Jeffrey has to share with you today. So that said, let's not keep him waiting any longer. He's a very busy man. Welcome to the show, Jeffrey.
Thank you, Stewart.
You are so welcome. We're so happy that you could squeeze us in your busy schedule. First things first then, Jeffrey, legal disclaimers. We have to start with that. It goes without saying that the information shared during this interview is for general information purposes only and does not contain legal or therapeutic advice for any individual case or situation. Now, listening to this information does not constitute an attorney-client relationship. Could we just double up and, in your own words, just expand on that for us, Jeffrey, so we're emphatically clear about what we're trying to achieve today?
In the interview, Stewart, I don't plan on providing legal advice to anybody. I'm going to talk about process and the importance of selecting the appropriate process for your family law matter, which I consider probably the most significant decision any client can make before going forward with a divorce.
Well, thank you for making that emphatically clear, Jeffrey. So to kick things off, could you please just describe your company, the people who you serve, and the situations that they find themselves in when they come to you for your help?
Well, I am part of the family law department of Shapiro, Blasi, Wasserman Hermann. It's a multifaceted legal attorney firm located in Boca Raton, Florida. And we do most everything in the civil sphere. We do not do criminal defense work. Most of the attorneys are well trained in their different areas of practice. My particular area of practice is that of family law, which I have been doing for over 50 years now. When I first started the practice of law, there were no specialties. So we would be doing just about anything that would walk in the office, which gave me a great background in being able to handle the different areas that are included in the family law practice, dealing with real estate, employment law, personal injury issues come up on occasion, contract law, commercial law, things of that nature, which are all part of the family law process. For most of my career, I was a litigator, and not just in family. I would litigate civil matters as well. There would be years I would have more jury trials than bench trials in family. But I found over the last 10 years that there is a much better way of handling family disputes than in a courtroom, which I believe is toxic to the families, to the parties, and especially to the children.
With that said then, Jeffrey, what are 2 to 3 common misconceptions surrounding your industry?
Well, there are 2 common misconceptions. One is that, and I'm speaking from a divorce standpoint, the first misconception is that people are going to find justice in the courthouse. And unfortunately, that is not necessarily the case. The second misconception is that lawyers are the enemy. And that is reflected in the overwhelming number of unrepresented parties who file for divorce on their own without utilizing a lawyer, which I believe is a grave mistake for most of the people who are doing this. There are various reasons that people have gone on the do-it-yourself routine, but I think it's unfortunate that there is the misconception that a lawyer is not going to be helpful to the client in the process.
What actually is the benefit of selecting your divorce process? Sounds like a logical question, but what are the benefits of doing that?
There are multiple benefits, actually, for collaborative law. The first and probably the most significant benefit of collaborative law over litigation is the control that the client maintains in the process. This is a client-driven process. It's not a legal-driven process. And the clients are provided a certain empowerment to be able to decide their own destinies in their own cases. Unfortunately, in litigation, clients have an approach that lawyers need to be their gladiators and slay the dragon or their spouse, which is a very, very unfortunate situation. But in the collaborative process, it's a peacemaking process that allows the attorneys and the team to work on solutions to the issues that are presented by the client. And to a very large extent, the clients have a say in how those issues are going to be resolved. And they're not necessarily legally based resolutions. They are resolutions that make the most sense for the family. In the collaborative process, I like to say that we look at the day after the final judgment of divorce has been entered to see how the family is going to fare going forward. In litigation, the process is designed to get the parties divorced. What happens afterwards is not necessarily the major focus of the process itself. The other benefits are certainly privacy. When you're not in court, you're not filing any papers. And unfortunately, there are a lot of bad actors out there who troll courthouse dockets to find out about the lives of different families by virtue of what has been filed in the litigation process. Because there is no court in collaborative, there are no filings until you get to the final hearing. Timing is another benefit. Courts, I know in South Florida, and I presume in most of the parts of the country, are backed up, where it's very, very difficult to get hearings on a timely basis. In the collaborative process, the clients actually are in charge of the timing by virtue of how cooperative they are in voluntarily providing the information necessary to move the process forward. There are no formal discovery motions or notices or anything of that nature. Everything is done on a voluntary and open and transparent fashion so that everything is in the open in order for the clients to be able to make a decision. Again, we deal with problem solving in the collaborative process. We build options to try to solve these different problems. And there's a lot of creativity that occurs in being able to come up with solutions for the problems that exist. And some problems are very complicated. I mean, your typical issue is where families may be surviving hand to mouth without any significant savings. What's going to happen when suddenly there are two homes that have to be supported? And the children are going back and forth between two homes and they have to be supported. So we need to look at the ability to solve these issues. The other benefit is that we have a team approach in the collaborative process. The mandatory professionals are attorneys for both parties. In order to start the process, you need the two attorneys in the signing of a participation agreement, which sets forth the terms and provisions of how the process is going to move forward. And they're typically fairly standard as far as the participation agreement provisions are concerned. And we include a code of conduct to make sure that everybody does what they're supposed to do. But the team approach allows us to also employ neutrals, a mental health professional who can act as a facilitator or coach to do a couple of things. Number one, make sure that the process proceeds forward in a relatively non-emotional basis. Divorce is very, very emotional. And the mental health professional is there to make sure that the parties' emotional needs are being taken care of. Nobody is being pressured to do anything. And also making certain that the attorneys act appropriately as peacemakers and problem solvers rather than gladiators. We refer to it as a paradigm shift for collaborative professionals, where we take off the helmet and we wear nice clothing to encourage more peaceful resolutions and peaceful solving atmospheres in the collaborative process. The other neutral is the financial professional. And whereas in litigation, attorneys will normally each hire a forensic accountant to help represent the party, in the collaborative process, there is one financial neutral who gathers all of the information that is provided voluntarily by the parties, crunches the numbers, and helps come up with a plan that would be satisfactory to both sides. The attorneys work together as opposed to against each other in the collaborative process. So it's a team effort to try to get a full resolution on behalf of the clients.
Having said that, I'm sure there are people out there who still have some apprehension, some fears around selecting a divorce process. In your experience, Jeffrey, what are some of the most common fears that people have about selecting a divorce process? And more importantly, how can they get past those fears?
Well, I think the biggest fear is cost. And it's a very reasonable concern. I mean, most of us are not, multi-gazillionaires where money is no object. And even the multi-gazillionaires try to watch their pocketbook. But the fact of the matter is that hiring lawyers, moving forward with any sort of litigation, is an expensive process for people. And if they are living hand to mouth and they don't have a lot of savings, it becomes very, very difficult. My standard speech throughout my career in connection with divorce interviews has been that you and your spouse are at a crossroads. You have worked very hard to accumulate what you can in connection with the assets of this marriage. And the crossroads is very simple. You can either agree to divide it pretty much between the two of you, or you can fight and try to kill each other and make the lawyers and professionals wealthy. Now, I leave it up to you to decide which you think would be more beneficial and more equitable from your standpoint. And it's a wake-up call, because quite often people come into a divorce situation with a lot of anger and distrust toward their spouse, which from a psychological standpoint, a mental health professional would be able to identify the reasons better than I. But these are two people who at one time loved each other, got married, more often than not had a family, and lived, hopefully a very, very nice life up until something happened. And for them to suddenly feel as if they have to take their individual battle stations and hire the gladiators and hire the protectors and the people who are going to fight for their rights is very, very unfortunate. They should be looking for people who are going to help them through the process rather than fight in the process.
Jeffrey, my observation in interviewing professionals like yourself is there seems to be a trend of, let's use your words, gladiators, moving towards using collaborative and mediation processes as opposed to litigation. Is that something you've noticed yourself within your profession?
Well, mediation has been around for many years. I remember when it was first introduced in South Florida, and quite interestingly, it was not well received by the lawyers, and it wasn't well received by the judges either. And I believe what happened was a judge went to sleep one night, and in the middle of the night had this epiphany over the fact that if people mediate and settle their cases out of court, I don't have to make that final decision for this family. They can do it on their own, which they should be doing on their own. And that judge talked to their colleagues And everybody said, what a wonderful idea. And suddenly mediation took off like crazy.
Do I detect a little tongue in cheek there, Jeffrey?
But seriously, I mean, it was not well received by any members of the bar, either the judiciary or the lawyers, when it was first introduced. And then everybody started to look at the benefits because people, I don't care what their educational background is. They're intelligent enough to be able to decide how they want to shape their futures. Now, whether it's possible to do it the way they would like it to be done is a different story. But they all have the tools to say, yes, this is what I would like to see my future look like after I've been divorced. And judges do not have that ability to enter final judgments based upon what people would like to see happen. They are bound by what the law provides them. And if they vary from what the law provides, that's what the appellate courts are for. And they get reversed because they didn't stick within the four corners of that box in making your final decisions. So in a divorce situation, in working with the family, your children, I mean, who best to decide the benefits for your children than the parents? And the mental health professional, as part of the team, works with the parents in helping to devise the parenting plan, which is utilized most often in family cases. At least it is required in the state of Florida when there are minor children. And they help them devise an agreement that is going to be beneficial for the family going forward. They devise an agreement where co-parenting is possible going forward after the divorce, instead of the parents having a lot of bitter feelings toward each other even after the court enters a final judgment of dissolution of marriage. That's why I pointed out before, we look at the day after the entry of that final judgment. What's going to happen to this family then? And we try to focus on what's going to happen to the family then. We just don't leave them on a desert island picking up the pieces of fractured divorce. We try not to. We try to come up with the appropriate solutions where the family can go forward, not living in the same household, but celebrating all of the wonderful events that children have, their religious events, their graduations, their weddings, and someday grandchildren. And being a grandfather, I can tell you that it's one of the greatest experiences that anybody can experience. It's just absolutely fabulous. And you don't want to destroy the relationships that you have with your children because you're fighting with your spouse.
So, Jeffrey, if there is someone listening right now and they find themselves, as you described it, the crossroads in terms of selecting the right kind of divorce process, what are 2 to 3 unknown pitfalls that they should be aware of and, more importantly, should avoid?
Well, unfortunately, it's a matter of education and educating the public that there is more than one way to skin the cat. Unfortunately, a lot of my family law colleagues simply default to the idea of, okay, let's file for a petition for dissolution of marriage to get a divorce. And the clients should be doing research on alternative methods of obtaining a divorce and educating themselves on what would be most effective and most beneficial for them in proceeding forward. If they have some background before they interview their potential attorney and they understand the differences between mediation, pre-suit, collaborative family law, litigation, simple as what we refer to as kitchen table negotiations with your spouse. If they understand the different processes that are available to them and the benefits of each and the detriments of each, they are in a much better position to be able to discuss what the appropriate process would be for them rather than simply defaulting to litigation, where lawyers who are not trained in the collaborative process and do not understand the collaborative process simply say, let's file suit, which is unfortunate for the public. So that's the first thing that they need to do. And there are plenty of places. Online education is greater than it has ever been in my lifetime. Look up divorce processes, look up collaborative family law, look up mediation, and you get a huge amount of information on any of these things before you decide which process to utilize.
Do you find yourself deciphering some of that information?
When I first started doing collaborative law, very few people were aware of the collaborative law process. Over the 10 years that I have been doing it, more and more people are contacting me because I am known as a collaborative family lawyer. And they've done their research and they understand that it's a much better way of obtaining a divorce. So you may have one spouse who is very, very much on board doing the collaborative process, and the other spouse may never have heard of it. And it's a matter of trying to educate the other spouse so that they can make a decision, because both parties have to agree on which process to utilize. And although I would like to believe collaborative law process can be for everybody, it is not for everybody. Sometimes there is too much anger, too much distrust, too much one-sidedness, imbalance of power, things of that nature, where somebody wishes to take advantage of the other spouse and win, okay? We don't look at collaborative law as providing winners, because honestly, there are no winners in a divorce situation. And the biggest losers sometimes are the children. What we try to do is minimize the losses to the extent that we can get win-win situations. We strive for those results.
Can you share 2 to 3 perceived obstacles that may prevent someone from seeking the help of a professional like yourself?
Cost. Not inexpensive. I've been doing this for a very, very long time. And from a collaborative standpoint, attorneys in my area, I would probably be in the upper 3/4 quadrant of my hourly rate. But I also do pro bono work. I've been a huge believer in giving back throughout my career. And I'm a strong proponent of pro bono work where for people who can't afford anything, they can barely afford to support themselves, they deserve representation as well. And in giving back, I have over the years always insisted on working with our local legal aid society to provide the pro bono work for these needy people. Collaborative law also has low bono for people who are in a little better financial position. And we also have class fee arrangements that we can make for clients. So there are a lot of different variations, but there's one other thing, okay? And I'm a firm believer in this. Personality-wise, there has to be a fit between the client and the lawyer, regardless of anything else. It's like choosing your doctor. You may be interviewing the best doctor in that particular field, but if you don't have a good feeling with that doctor, you're not going to want to hire that doctor. Well, the same thing true with a lawyer. There has to be a personality fit to be able to go forward with somebody. My personality may not match with a lot of people, and my personality usually matches with most, but some people want that gladiator. I'm no longer the gladiator because I don't take on any new litigation cases. I'm finishing up some that I have in the office, but I sell people from the standpoint of me being a peacemaker, not a gladiator at this point. A problem solver, not a problem creator.
I think that personality match is really important, and especially when it comes to full disclosure, because if you are taking on the services of an attorney or any kind of divorce professional, then you're going to have to share some really personal information. And if there's not a personality match, then there's the danger of you not sharing information which could then work against one. Is that correct, Jeffrey? Am I on the right lines?
Well, you attempt to stay away from too much personal information because the fact of the matter is, in collaborative law, it's not about us, it's about the client. And we concentrate on the client's personal information and how we can help with that, knowing that personal information. Yes, I will often share with clients that I have been divorced, and it was not the most favorite time of my life. It probably was one of the most horrible times of my life. And unfortunately, I did not have a friendly divorce. It was tried for several days and went on appeal. It was reversed on appeal, and we wound up settling it for what I had offered originally, without all of the turmoil that took place in between and without all of the costs that were incurred in connection with what was going on. And it's very, very unfortunate. It left our children somewhat scarred, unfortunately. And there was a lot of mea culpas and I'm sorry's and therapies to mend those rifts. So I can empathize with what people go through by virtue of my own experience. And from that, I always knew that there had to be a better way. I finally was able to find that better way. One of the obstacles that a lot of litigation family lawyers throw out is the fact that there is a disqualification provision in the participation agreement that provides that in the event the matter is not settled and a court is needed in order to resolve the issue, not just to get a final judgment, but to resolve outstanding issues, the lawyers and the professionals who are part of the team are not allowed to participate in the litigation process. We have to withdraw from representing the client. Now, statistically speaking, the state of Florida, through the Florida Academy of Collaborative Professionals, keeps statistics, and over 80% of the collaborative cases have positive resolutions where the only thing left to be done is for the court to enter a final judgment of divorce. So there's a very, very strong, high percentage of successes in the collaborative process. Some of the issues that have occurred is that perhaps clients should not have been in the process to begin with, and the attorneys didn't properly vet it. But the disqualification provision, from my perspective, is a positive, not a negative, because it has everybody signing an agreement saying we are all in doing everything that we can to try to create a favorable resolution that everybody can sign to successfully conclude this process. And if we are unable to do it, we're done. We can't go forward on your behalf. So the attorneys, rather than always looking at the possibility of, well, we can earn more money if this thing breaks down and we can go to court, there is no more money to be made if it breaks down. So everybody is on board and concentrates and focuses on a successful resolution when you start the process. And that's really a huge positive for the clients, knowing that your attorneys aren't looking down the road at anything other than the success of the process.
So, Jeffrey, when it comes to selecting your divorce process, which is your topic for today, and obviously keeping your client's confidentiality in mind, could you please share just one example of how you've been able to help somebody succeed in gaining the results they were looking for when they initially reached out to you?
Well, when I have an initial interview with a client, I try to avoid discussing the law because I don't want the client to become positional in connection with the process itself. I don't want them to come in to a team meeting and say, well, under the law, I'm entitled to this. Well, under the law, you may be entitled to it. You may not be entitled to it. You may be successful in obtaining it, and you may not be successful in obtaining it, regardless of what the law is, because when you factor in the credibility of witnesses and who testifies and what goes on in a courtroom, a lot of crazy things can happen and a lot of crazy outcomes can occur, regardless of what the law says. So what I do is I try to ask them, what are their goals and interests? How do they want to see the process proceed forward? And most people in the collaborative process, when the first team meeting arises and they are asked about their goals, generally, both sides say, we want this to be as peaceful as possible. We want it to be as quick as possible. and least costly as possible. We want to preserve the family unit. We don't want to do anything that's going to harm our children. Those are generally the agreed upon goals on both sides in a successful collaborative process. And then we ask for interest. And interest may be diverse. The parties' interests may not be compatible. And that's where the creativity in the process of option building comes in to try to address both sides' interests in a way that we resolve them satisfactorily to both sides. Not everybody is going to get everything they want. That's a surrender. That's not what we do in the collaborative process. We option build. We create opportunities to have the clients control what their destinies will be by openly negotiating across the table with each other, or even sitting next to each other at a team meeting where they can openly discuss why they have these interests, why their needs are such, and why they are asking for certain things, rather than just making demands and being positional, where somebody would walk in and say, well, I want the house, and if I'm not going to get the house, then, let's litigate. That's a positional situation, as opposed to somebody coming in and saying, we have 2 kids who in the next 3 years are going to graduate from high school. I'd like to be able to keep the house for the next 3 years until they are both out of high school. And at that point, I'm not so concerned about providing them the shelter that I want to be able to provide them during this period of time. Is it affordable? Can it be done? Would the spouse be able to live in an appropriate manner and fashion where the children would have 2 households that they would be able to go to, not reluctantly, but willingly and with love for both parents? That is something that we need to determine. But it's not a positional thing. It's something that, this is my interest, and this is why I have this interest.
So as a reminder, ladies and gentlemen, my guest today is collaborative family law attorney, Jeffrey Wasserman. And Jeffrey has been addressing a very interesting topic of selecting your divorce process. Now then, Jeff, you've shared some great insights so far. So let's just switch gears for a moment and talk a little bit about you. Now, you've already mentioned you've got vast experience in the divorce industry. So please go ahead and tell us a little bit about your backstory. What was it that led you or even inspired you to become and do what you do today? Please go ahead.
It's kind of interesting. When I started college, I was in pre-med. And as many freshmen often wind up doing, I was having more fun than studying. I realized getting into medical school was not going to be an easy task for me if I was going to continue in this fashion. And it was so long ago, the requirements for getting into law schools were not as demanding as getting into medical schools. And my uncle, who was only 12 years older than I, who was like an older brother, was a lawyer. And I always idolized him. And I said, well, let me look at becoming a lawyer, okay? And I majored in English. I minored in philosophy, which helps me with the creativity issues. And then I went to law school after I graduated from undergraduate school. And I immediately took to it like a duck takes to water. I enjoyed doing what I was doing. I liked helping people. I became very, very successful very early on in my career. I was hired by 2 very well-established lawyers in Hollywood, Florida, who mentored me and taught me the ropes, so to speak. And I put in a lot of effort because I really loved being a lawyer. And when I first started practicing, because there were no specialties, we did just about everything in our 3-person law firm, but it was mainly litigation-oriented work that we were doing. So I became a trial lawyer. And then little by little, I started getting more involved in the family law aspect of things. I ultimately became the chair of the family law section of the Florida Bar. I chaired the Family Law Rules Committee of the Florida Bar. And I've done a lot of bar work throughout my career, basically starting in the bicentennial in 1976, where I was chair of the bicentennial committee for the Florida Bar. So I always believed in contributing to the profession and giving back to the profession. I served on grievance committees as a young lawyer, and I've always been very ethical minded in connection with the practice of law, wanting to weed out the bad apples, so to speak, and get rid of them because of, unfortunately, the reputation that has besmirched a lot of lawyers. So I've always been true to my profession. I love doing what I do, and I really enjoy helping people. When I was a litigator, I enjoyed winning in court, and my batting average was very, very good.
So let me just jump in there then and expand on that. You said you love helping people. So if you're able to help someone choose the right divorce process and take them on that journey from where they were when they initially reached out to you to their desired outcome, what do you get from that then, Jeffrey?
Just personal satisfaction of having done a good job and benefiting people. But what I realized when I was first introduced to the collaborative process was that I was not necessarily helping people in divorce settings by winning in court. I may have won for them. I was a great gladiator, but the effect that it would have on the family, unfortunately, was not always a positive effect. And the outcome was not always positive to the family. And it bothered me to some extent because I realized that there had to be a better way. And in this process, I'm finding that better way in helping people getting to where they need to be and having them participate in the process. In litigation, the lawyers control everything. They control the negotiations. They control when you go to court, when you don't go to court, how you settle, when you settle. That's not true in the collaborative process. The parties are in control. The clients are the ones who make that decision. They are empowered to control the process and empowered to control their destinies.
So if there's somebody out there who's evaluating a professional in your field, in other words, looking to possibly take them on, to hire them to represent their situation, what are some of the things that they should be looking out for in that professional so they can make an educated decision of whether to move forward or not?
Well, number one, if the professional is not willing to openly discuss all of the processes available for the client to make their selection on which way they want to go, that's a red flag. But in a lot of cases, the client is simply looking for that gladiator. They don't want to know about the alternative dispute resolutions. They don't want to know anything other than, I'm going to hire the killer. I'm going to hire that person who's going to benefit me the most. I don't care what happens to my spouse. And unfortunately, when they say that, in turn, they're not caring what happens with their children, which is unfortunate. They don't look at it that way. But, they're so angry or so distrustful when they come into the divorce process. They really can't see beyond just harming their spouse and taking advantage of their spouse. And there are lawyers out there that basically have an open invitation saying, you're my kind of client, because there's no limitation on the cost of what's going to occur going forward, both financially and emotionally for the party.
So, Jeffrey, if there is somebody listening who would like to know more about you and how you could possibly help them, what would be the best way for them to connect with you? One, and most importantly, what actually happens when they do reach out to you? What's your process? People want to know if there's a risk to reach out to you. Are you going to hit them over the head with a Fred Flintstone club and drag them to the back of your office and steal all the money out of their purse? So people, go ahead and just explain your process for us, please.
I can speak fairly quickly about that. I can be contacted through my email, initial J Wasserman at sbwh.law. Potential people can also contact my assistant at the Shapiro, Blasi, Wasserman and Hermann law firm at 561-477-7800. If you contact me by email, you can indicate what you would like to hear from me. You contact my assistant, and you can ask for it through the switchboard. My assistant can set up a conference call so that we can discuss the process. I will spend a half hour of my time without charging a client to, number one, let them know who I am, and number two, discuss the different forms of processes that may be available so that they have the insight of, well, is there a personality fit or not? Also, can they afford my fees or not? Which is always important from their standpoint as well as mine. And also for them to get a taste of the different methods by which they can move forward so that they can hopefully speak with their spouse and come up with the appropriate method that will be least costly, both emotionally and financially to them.
Fantastic. You know something, after spending some time with you today, Jeff, you sound so good that I think I'm going to file for divorce just so that I can just come and hang out with you for a little while.
Well, I'm not going to promote any divorces, Stewart. Okay?
I knew you'd say that.
I try to help people through divorce. But the other thing I've always discussed with my clients is whether or not they have investigated all possible means by salvaging the marriage before they are ready to pull the trigger and move forward with the divorce. Because once you pull the trigger, it's hard to take it back. But I will tell you, the 3 most successful collaborative cases I had ended in reconciliation.
Isn't that all? That's quite
I can't think of a better result.
Okay, ladies and gentlemen, that's all we have time for today. Once again, you have been listening to collaborative family law attorney Jeffrey Wasserman. Thank you so much for sharing so generously with us today, Jeff. You have certainly demonstrated that you are a true educator and advocate for your client's success. So thank you.
Well, I appreciate the opportunity of coming on your program. I thank you for that opportunity. And for those who are listening, educate yourselves. Do some research before you even pick up the phone or contact the lawyer, whether it be me or somebody else. Find out what's available. Do your own research and try to figure things out a little bit on your own and then get the legal advice to fill in the blanks. Thank you, Stewart. And thank you all listeners.
You are so welcome. It's been a pleasure having you on the show. And I'd also like to take a moment to say a big thank you to you. Yes, our listener. Without you, Jeff and I, we'd be sat here twiddling our little thumbs and we wouldn't have anybody to speak to. So thank you for joining us on what can only be described as an insightful and informative conversation with one of the leading collaborative family law attorneys in Boca Raton. I hope I pronounced that correctly this time, in Florida today. Again, his name is Jeffrey Wasserman. Please make sure to check him out, because if there's one thing I'm sure of after listening to Jeffrey today is that you're going to be in good hands and a safe place to get started. So that's it. Once again, my name is Stewart Andrew Alexander, and we'll be back shortly with some more leading divorce professionals in this, our series, Let's Talk Divorce Conversations. So until then, take care, have a great day, and always remember, conversations with care save your children's despair. Now you're getting divorced. I know, it's not fair. No matter the pain and the troubles to bear, the children come first, and for them we must care. When you feel your blood boiling and your voice you must air, remember, the children are listening, and for them it's not fair.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.